Aaron?
Yes, Your Honor. Dan Douglas for the Alliance for Retail Energy Markets, the Direct Access Customer Coalition and the Western Power Trading Forum. Okay. We agree with the phasing that you have suggested and described. We are particularly appreciative of the fact that you noted in your comments that the issue of replacement power will be looked at. We believe that's appropriate, and we believe the prudence of the replacement power activities needs to be examined. We would also echo the comments of counsel for DRA Turn and EPUC, suggesting that it would be prudent to move ahead with examining the issue of whether or not these costs should continue to be included in rates, and that the suggestion that it be done with a concurrent briefing schedule while we proceeded with phase one would make sense to us.
All right, thank you very much. Joint parties?
Your Honor, I'm Aaron Lewis, appearing for the joint parties, which for the record are the National Asian American Coalition, Latino Business Chamber of Greater LA, the Ecumenical Center for Black Church Studies, and the Chinese American Institute for Empowerment. Commissioner, Your Honor, thank you. Did I understand from Your Honor's earlier comments that community outreach was to be included in phase one?
Yes.
It is, okay. And did Your Honor, we have a motion pending to that effect, but did Your Honor have? We'll
address that in the scoping memo.
In the scoping, okay. Thank you, Your Honor.
But I am aware you raised that issue, and as did another party or two.
Thank you.
Okay. Nevada Hydro Company?
Yes.
Any comments?
Your Honor, David Cates for Nevada Hydro. We don't really have any comments at this time.
All right, thank you. City of Riverside?
Good morning, Your Honor. Susan Wilson on behalf of City of Riverside. We have no comments on the scope or the schedule, and thank the Commission for the opportunity to participate in this proceeding.
Okay. Southern California Gas?
Yes, Your Honor. Michael Thorpe representing Southern California Gas Company. Our sole focus here is getting clarification as to whether natural gas service and reliability issues are going to be considered here, or whether we can continue to consider them in other proceedings, even if they have some relationship to the song's outages. It sounded like from your earlier comments that the direction from the Commission is going to be for us to continue to consider those issues in our TCAP or in some other proceeding, and with that, we're completely happy with the schedule, and we also think it makes sense. It sounds like you've got a very complex and potentially contentious proceeding here as it is. Don't necessarily think you need to inject natural gas service and reliability issues here when there's a good home for them elsewhere.
All right, thank you very much. UCAN?
Yes, Your Honor, good morning. Don Killian, the Executive Director of UCAN, and we actually would echo Mr. Giesman's comments about removing from rates, or from the rate base, as soon as possible, the SONGS facility. We also agree with DRA and Turn in regards to the briefing schedule on the legal issues as soon as practical. And with regards to Mr. Aguirre's point that there was a prior Commission proceeding and there is a record there that we could all review, but there are several volumes that are sealed, we would urge the Commission to actually consider unsealing that record for the parties' review and make that record as part of this proceeding. Thank you.
All right, we'll take that into submission. Thank you. It's actually been raised in some of the some of the comments that were filed about getting access to that record. So we will take that under submission. Women's Energy Matters?
Yes. Hi. I have
Can you identify yourself for the record?
Oh, I'm sorry, Barbara George, the representative.
Comments on schedule?
Yeah, the comments that we have are that there is, as I said, I have two comments. One is the concern about the delay in taking the reactors out of the rates. I agree with some of the other comments that have been made here, that should happen as soon as possible and the policies can be understood without the exact details. On the other question that I have is phase 3, the options for repair. It seems to me that we're looking at that awfully late after the fact, because right now there are activities going on by Edison. The investigation is costly. I mean, I'm quite concerned that they are planning on restarting without repairing or without any extensive repairs, but I'm sure they're going to do something, and that has a cost. And I'd like to know what that is. I think that the Commission should know what that is before before allowing that to go forward in rate. And basically, they're going to assume that we're going to pay for that, and the ratepayers will pay, and I don't think that that should be assumed.
It isn't assumed. Let me, a couple of thoughts on that. One, the question of what Edison's intentions are with these two units is not yet clear. They have an application, as I think probably most people in this room know, pending with the NRC regarding a partial startup of Unit 2. That's something that makes a difference in assessing costs, because at some point there will be a discussion, a conversation, and hearing on the question of what are the options, what are the costs. Second, if there is a repair option that is a capital expenditure of 10 million or more that will be identified for in the monthly reports of Edison, will come into this proceeding for review. So, no, I don't anticipate that there will be multi-million-dollar repairs just undertaken willy-nilly without the commission or the parties being aware. Mr. Warden, can you confirm that that is an accurate description of your disclosure commitments?
Yes, Your Honor, that is accurate, with one clarification. The order directed Edison to inform the commission, and presumably by a copy of service to the service list, of plans for a capital project greater than $10 million in a Tier 1 advice letter prior to committing the money. We would also memorialize that in the monthly report to be filed subsequently.
So presumably that would give parties an opportunity, if they had concerns, they could bring a motion for further information, could make data requests, or bring a motion before us. So I anticipate that the parties will have advance notice of repair considerations if Edison's making them, and will have an opportunity, if parties so request, to consider them. So I think that there are notice pieces in place, and your other comments are noted about the rate base.
Okay, then my second question, actually this is sort of a piece of a third, is a question whether or not when they file applications, does that kick us into other proceedings then, or is that the application going to be considered here?
Our intention, and it was outlined in the OII, was to consider consolidation. For example, the general rate case decision that was adopted last November for Edison's 2012 rate case directed them to file an application regarding all of the SONG's 2012 costs, and directed that it would be consolidated with this OII. Similarly, it is our expectation, and was noticed in the OII, that the steam generator replacement project application would be consolidated with this OII. We may well expand the scope, as we have suggested, beyond just a simple review, because circumstances have changed, and obviously there's more to look at. More questions about the expenditures following the shutdown, and what expenses they expect to incur going forward. So,
okay, my last question
has
to do with the short and medium term replacement resources. I think that those are potentially very contentious issues, and right now in the long-term procurement proceeding, which we're involved in, there are a lot of discussions about the possibility of using preferred. Well, actually, there is a proposed decision to use 450 megawatts of preferred resources in the LA area. They haven't considered the Los Angeles without San Onofre yet. That's coming up. But those types of issues really are appropriate for the LTPP, because the background that we've dealt with in the LTPP is very complex, having to do with what are the chances and the ability of the ISO and the utilities to use the preferred resources for replacement. And the preferred resources are almost all short and medium term rather than long term. And so I ask that we continue to address those in the long-term procurement proceeding. I have put in a proposal in this proceeding to.
Yes, we have that
Yeah.
proposal, and I won't have you reiterate that because it's already on record.
Yeah, I don't
Okay, sorry,
want
your point is
to
taken.
reiterate, but I have a question because I had asked of going forward immediately. And obviously, this summer is the question, is the short and medium term. And so we need to make some sort of decision on those short and medium term resources really fast if we're going to use preferred resources. So I think it would be best to do it in the long-term procurement proceeding because it's a whole ball of wax that I don't think we have the bandwidth in this proceeding to do.
Okay. All right. I thank you for your comments, and they are already on record. Other parties? I'm going to go to parties who haven't had an opportunity. Yes.
Sarah Myers again for SURT and Internog. First of all, I think you've heard from a couple of people, and I very much appreciate Commissioner Florio explaining the link between the LTPP and this potentially. This is a matter of great concern because parties such as SURT and Internog want to make sure they're in the right place at the right time. But in the scoping memo, I guess I would ask that there is some effort spent on explaining the connection with the LTPP and next steps. But also out there are two new Edison and SDG&E applications on augmenting their demand response programs for this summer in response to the songs potentially not being available. So we just want to make sure we have the comprehensive list and we know where to be. And I very much appreciate that. Thank you.
All right, thank you. Other parties?
Michael Dorsey for DECA. We're not a
Actually, I've had a chance to look at your motion as you amended it pursuant to my instructions, and it's an appropriate motion, and I'm going to grant it so that Distributed Energy Consumer Advocates is a party.
Thank you, Your Honor. And I have a question about the scheduling. And in what phase would the value of residential distributed generation be considered in light of the increased cost of the outage? And I know this might, given Commissioner Florio's comments, this might vary based on what happens with SCE.
A general advertisement about the value of residential solar is probably not relevant. If it's proposed as some kind of alternative to something that Edison is proposing to do, then it may be relevant here. It may also be relevant in LTPP.
Okay. Other parties? Yes.
I'm Martha Sullivan. I'm representing the Coalition to Decommission San Onofre.
All right.
And I would just like to emphasize, based on some of the other parties' comments, from our perspective, on behalf of the 8.5 million people who live within 50 miles of the San Onofre plant. The U.S. Nuclear Regulatory Commission is currently considering Edison's proposal to restart. We've talked about it. In our mind, we don't understand how we can possibly consider that proposal without knowing what it costs and who's going to pay for it. It doesn't make any sense to the public, where Edison has already admitted that they've spent, close to or more than $400 million.
So is your question whether within the scope of this proceeding there will be a consideration of the cost effectiveness of...
How are these two agencies' decision-making processes going to complement each other effectively?
We have
because how can we have the NRC give Edison the go-ahead to restart an admittedly defective nuclear reactor without knowing how much it's going to cost and who's going to cost?
Okay, let me give you one observation because I'm not going to engage today in substantive discussions about the pros or cons of what happens to songs. The NRC has a clear jurisdictional authority over the operating license of this generating station, the 2 units 2 and 3. That is not commission jurisdiction. That's the NRC's licensing decision. What is our jurisdiction is the reasonableness of the costs, which are going to come back to ratepayers. And to the extent that, for example, NRC gives them some authority to restart. There's costs associated with that. And there will be a discussion about that within this proceeding. That's our fully within the scope that we anticipate.
Will there be discussion of that before they're allowed to actually restart and start that cash register running?
Well, we don't have any control over what the NRC does or the timing of it. That's them. If they choose to wait and see what the costs are, they can do that. If they choose to plunge ahead without it, there's nothing we can do about that.
And we are painfully aware of that.
Yeah.
Because we're very active with the NRC as well. I guess what we're asking is, you know, it's like the two agencies are pointing their fingers at each other. The NRC says we don't have, you know, it's not our mandate to consider cost. And the PUC is saying it's not our mandate to consider safety. So what we're asking you is you control the purse strings and you control what ratepayers are going to be responsible for. And it just does, I mean, again, it doesn't make any sense to the average homeowner who's responsible for their bills that you give, you know, a blank check to a contractor to start a project and run up the bills without any kind of, you know, contract about what they're going to do and how much it's going to cost. That's all ratepayers are asking for, is for the commission to exercise its jurisdiction over what this is going to cost and who's going to be responsible for it before we let Edison start running up even more bills over the $400 million they've already admitted they've spent because of this failure.
Thank you very much for your comments. Other parties? Yes, sir.
Yeah, Steve Zeltzer, United Public Workers for Action. Well, we second your question. Frankly, we think it's outrageous that they're continuing to able to collect money from the people of California and the ratepayers. It's been closed for over a year. And there's no real evidence that they're going to be able to reopen this plant. In fact, they have given a statement that they're going to lay off 50% of the workers at that plant. And they told the union that. Now, if they're going to lay off 50% of the workers and then reopen the plant and put the public in danger and put the workers in danger, we think that's outrageous, and that should be part of the scope of this commission. How can you lay off 50% of the workers and then restart a nuclear plant?
It is.
That's an issue. Okay, I think that should be part of the scope of this commission.
It is.
Okay, I also don't think that we can give proper guidance to this utility. I question their factual truthfulness. For example, whistleblowers have been fired and retaliated by the Southern California Edison. Now, this is a question. How do we know what the real circumstances are at the utility when they retaliate against whistleblowers who are talking about what the real situation is at the plant and the potential costs of really taking care of that plant? This is a real question. So I think the question of whistleblowers and retaliation by the workers at that plant should also be part of the scope. Additionally, the question of cancers, the cancer epidemic in that area as a result of the plant. Workers are getting sick and residents are getting sick as a result of the plant and what it's doing. Who's going to pay for that? Should it be the people of California or that company which is running that plant? That also should be part of this, looking at the cost of this plant. I think that the question really raises is whether or not we're going to allow private companies like Southern California Edison and other companies like PG&E who have no control by the public, or whether we're going to put the utility industry under public control, and whether that's the proper way to have a real oversight and a real control of energy in California. Because we've seen, and again, case after case, where these companies have lied to the public, they've lied to the workers, they've lied to the people, and they seem to get away with it and oblivious to the cost to the people of California. And that's what we're saying. Let's put that as part of the scope of this, whether or not it should be run by a public agency or a private agency that is more interested in profits than telling the truth to the people of California and protecting the health and safety of the workers and the public. That's where we stand on this commission and what you should be doing.
All right, thank you very much. And provide it to the court reporter after the hearing that, to become an information only recipient of the service of all of the documents in here. But this pre-hearing conference is for parties, and I'm looking for any other party.
Thank you very much.
Yes, sir. You a party?
Shumavan with DECA. I just wanted to clarify after we talked a little bit in response to Commissioner Florio's statement earlier. There's a separate scheduling question that we still have, which would be around perhaps a more nuanced characterization of distributed generation in light of the capacity and energy shortages that we're seeing right now, and that is the appropriateness of separately handling any cost allocation associated with the SOMS units 2 and 3 outages for residential customers who actually own existing distributed generation in terms of the capacity that they are bringing or make available by having generation on premises, as well as the value of the avoided costs of energy associated with both on-site consumption of electricity that they're generating and any generation that is exported to the grid. And that is, I think, a separate consideration than the point that Commissioner Florio made earlier about a general advocacy of distributed generation as a replacement alternative on a forward-going basis.
All right.
Excuse me.
Any party? Okay. You need this gentleman's name for the record.
ARAMSHUMAVON.
Thank you. Okay. Other parties that have not spoken before? Yes, sir.
Norman Peterson for Southern California Generation Coalition. We support your proposed scheduling, and we also appreciate your recognition of the point raised by Mr. Thorpe and also as raised in SoCal Gas's motion to intervene about leaving gas reliability impacts for other proceedings.
All right. Other parties that have not spoken. You're an information person right now.
Informational party? That I just wanted to add for the record.
This is a proceeding for parties. As you can see, it's very full. It's not an opportunity today for public comment. Okay. Other parties that have not had an opportunity to speak. Anyone? Ms. Sheriff, you had your hand up for me to come back to you, so I'll give you your opportunity here.
Thank you very much, Your Honor. I had a quick clarifying question for Mr. Warden, or possibly you or Commissioner Florio. The Tier 1 advice letter filing for $10 million capital investment, $10 million or more, is that part of the Phase 1 general rate case decision? Because it seems to me
that was part of the OII that ordered it.
Okay. And Tier 1s are effective upon filing of the advice letter. Would that $10 million in costs or more be reviewed here as well?
I would believe so, because it would be part of Phase 3 in the steam generator replacement, which is where you're going to be making your capital expenditures in the near future. Okay. So, Mr. Weissman?
If I may briefly respond, Your Honor, just to one comment that was, I respectfully disagree with many of the comments that were made, but I'm not going to respond to them other than
I'm
just
sure there's
one
plenty
point.
of disagreement here today. You can have a minute here to address any clarifications you would like to make regarding the scope and phasing.
Thank you, Your Honor. There was one point I wanted to react to, and that was the Western Power Trading Forum, Mr. Douglas's comment to the effect that his understanding was that Phase 1 would include a review of the of the prudence of the procurement of replacement power costs, the prudence of those procurement practices, which is not consistent with our understanding of the scope of this proceeding. That prudence review of procurement would be something that would typically be handled in the quarterly compliance review, the ERA proceeding. I understand.
I believe that we will be bringing in the 2012 procurement costs for reasonableness review. I don't think you filed your ERA on that yet, though. Is that correct?
I'm not. I don't believe it has.
I think you've done the forecast ERA, but not the cost recovery ERA. But it is our intention in Phase 1 to look at replacement power costs and avoided costs in 2012.
May I be heard a little bit further on that? Thank you, Your Honor. We understand that phase one will evaluate or will determine what those costs are, and that as a result of determinations made in phase three, there could be some determination made about the recoverability of those costs. But that's distinct in our mind from the prudence of the procurement practices themselves, which is an issue that's typically addressed in these other proceedings. And we don't think it would be appropriate or practical, frankly, to try to evaluate whether the least cost best fit methodology under the AB 57 plan was carried out appropriately in the context of this case. Thank
you. Briefly, I'm going to give 2 minutes to Ms. George.
I have a question.
All right.
On the steam generator replacement costs, wouldn't that include the cost of them failing? In other words, all the money that had to be spent this year, wouldn't that be added into the cost of the steam generator replacement project?
All costs related to the steam generator replacement project are to be aggregated in the application that Edison files pursuant to the direction of the earlier decision from 2004. As my understanding. Mr. Wiseman, you look as if you disagree.
We certainly would be happy to report all of the costs that have been incurred. It would be our position that pursuant to the 2004 decision, what would be relevant for the application would be the costs that were incurred up to the point that the steam generators went into service and were used and useful. So the other costs that were incurred since that point in time are certainly things we would report, the Commission can review and evaluate, but in our view, that would not be subject to the cap that was established in that decision.
All right. Yes, sir. Can you please identify yourself?
Yeah, Larry Chassett with Friends of the Earth. I just wanted to restate Sarah Meyer's comment about having the scoping memo clarify to the extent possible the interconnection of the LTPP consideration of alternatives, both short and medium term as well as long term, to the extent you can do that, because I think that's going to really help us clarify how we're going to address those questions. Thank you.
All right, thank you. I saw another hand back here.
Yes, Your Honor, Dan Douglas again in response to Mr. Weissman's comments. This may be a definitional issue, whether we're talking prudence review or a reasonableness review, as you put it. We believe this whole proceeding is about prudence, and that the expenditures and the costs that the utilities have made, whether it's with regard to the steam generator, the emergency actions they have taken, or the replacement power, are all issues that are fair game and ought to be considered in this proceeding, and that prudence is clearly an important part of what should be considered.
Okay, thank you. Anyone else?
Yes, Your Honor, I'd just like to add.
Mr. Gaisman and then Mr. Aguirre?
Yes, Your Honor.
Your Honor, I had 2 comments regarding discovery. We're
going to get to discovery, so why don't you hold that thought. Mr. Aguirre, and then we're going to move on.
Your Honor, I just wanted to quote back to Your Honor from the decision of A040226, wherein it said, if the SGRP cost exceeds $680 million, or the Commission later finds that it has a reason to believe the cost may be unreasonable, regardless of the amount, the entire SGRP cost shall be subject to reasonableness review. So
yes, I have that. I have that. We're aware of that record.
But my only point was this, Your Honor, that with that being the case, that means that the Commission retained jurisdiction to look at the totality of the costs associated with those generators that were supposed to last 18 years and lasted 2 and 1 year. So the entirety of the cost should be included based upon the prior decision of the Commission.
Yes, for the record, he's referring to ordering paragraph number 5 in the original decision on the steam generator, which is 0512040.
Thank you.
All right, let's move on. I just want to touch base on discovery for a few minutes and make sure that everyone understands discovery should be well underway. And I expect parties to meet and confer if there are any problems and try to work it out before you come to me. I want everything resolved except for the very last items that you can't come to some kind of an agreement on. To the extent that Edison and San Diego Gas and Electric are providing testimony under seal, I expect two things. One, I expect the redactions to be surgical and not broad, and I expect motions to support that. Any questions about discovery? Mr. Reed?
Yes, is there a law in motion, Judge, for this proceeding?
I am the law and motion judge for this proceeding. And according to our rules, of which I follow, you are required to meet and confer before I see anything. Any other questions? Mr. Giesman?
Your Honor,
Yes.
we would request that Commissioner Florio exercise his authority under Section 583 to make clear that all information developed in the course of this proceeding, except that which is statutorily exempted from public disclosure, be considered public documents and be made available to the public.
All right, duly noted. Anything else on discovery? Yes, Mr. Giesman?
One second comment, Your Honor. The OII spoke of potentially having some common starting data that the assigned commissioner or perhaps yourself would direct the utilities to provide prior to the pre-hearing conference. Now, we've had a busy time prior to the pre-hearing conference. We thought it was a very good idea when the OII was adopted. We suggested several areas for such common information in our motion seeking party status. Rather than repeat that now, I'd simply inquire, do you have any intent to make such an order?
I guess I'm confused about what you're asking. What do you mean by making information available?
The OII said that the assigned commissioner and/or the administrative
Refer me
law
to the
judge.
page, please.
If I may, Your Honor, I believe it's page 16 of the...
16, okay. Thank you. Oh, great, one page I'm missing. Okay. Why?
Here, and
And so, all right, let me take a look at it. Let's go off the record for a minute.
Pardon me, I'm sorry.
Right, okay, so let's go back on the record. So the OII initially directed Edison to and San Diego to present some basic testimony on their position regarding the removal from rate base. We have subsequently issued a ruling requesting a broad array of testimony providing information on this information which you're referring to, which would be dates and causes of the outages, the status of the investigation, and costs incurred. That kind of information is being submitted tomorrow, is the due date for that. So that's how we're going to proceed. This is going to be an evidentiary hearing. We'll be proceeding on an evidentiary basis. There'll be testimony. There'll be a chance to reply and a chance to rebut. So I think that generally speaking, there has been some general basic parameters of the outage information has come forward in the filing so far. If there's other information that you or any party seeks, you're welcome to submit a data request to Edison.
Thank you, Your Honor.
Discovery question?
Discovery question. Yes, Ms. George.
In, I think it was a general rate case for PG&E, there was a website where all of the data requests were posted with the answers that were available to all the parties in the case.
We've already discussed that point, and they've agreed to do that. Next.
Okay, great.
Yes.
I have more, Martha Sullivan again. I have more of a clarifying question.
On discovery.
Yes, on discovery.
Okay, go ahead.
Edison and SDG&E have filed a motion for a protective order. So how does that color this whole?
That motion is under submission and has...
I'm sorry?
That motion is under submission and has not been ruled upon. So right now, what's happening is they will proceed as they do in other proceedings where the rules require, depending on whether it's discovery or testimony, there's description of how to proceed, which is generally a public version and a version under seal that they seek a ruling, and if so, then there's non-disclosure agreements that the parties work out for access to that information. There is certain information, and it's not just statutory, there's also a line of decisions here at the Commission about certain information, particularly power procurement areas, where there are protections in place for that kind of information in the balancing of public interests. So I would say there is no protective order in place. To the extent that Edison brings forth testimony or wishes to file something under seal, there's a process, and there's a process to object.
So you're, just so I understand this completely, so you're saying that we should assume there's a protective order in place?
No, I've not issued a protective order.
Okay.
What you should assume is that you need to watch what gets served or what gets filed, and if you disagree with motions by the utilities or any other party to have documents filed under seal or the record sealed as to testimony, every party has an opportunity to object and bring it to me to decide whether it is appropriate to have restricted access in the balance of rights that are confronted when we reach these kinds of issues.
Discovery question, Your Honor. In the documents that Your Honor, the documents that the Commission included in the OII, there was a statement made by the NRC that said, due to modeling errors, the SONGS replacement operations were not, generators were not designed with adequate thermal hydraulic margin to preclude the onset of fluid elastic instability. So there does seem to be a consensus that it was a design and modeling problem. May I just ask, just to cut to the quick, would it be Your Honor's intention that those design and modeling documents that are in SCE's possession, that those would be considered to be protected?
I'm not going to pre-rule on anything.
Okay. But
all right.
But I'm just asking that.
And I'm telling you the answer is I don't know. I don't have anything in front of me to look at or to make a decision on. I don't have a motion. I don't have a document.
But that document was included in the OII that the Commission released.
But no one's moving it into the record. No,
well, the OII is in the record.
OII is filed. Whatever's in the OII and the public document is public.
Right, but all I'm saying, Your Honor, is that that was included with the OII, signed by all the commissioners, and that was a document that was included, and it was a finding of the NRC. And I'm just asking, so that we can cut through, if that seems to be the issue, that it was a design and modeling problem from which all else basically rotates, then could we just make an inquiry of SCE if they intend to turn over those design and modeling documents?
You are free to pursue whatever data requests you like, and if the parties cannot agree, then it will come before me in a motion.
All right, very well.
Mr. Weissman?
Thank you, Your Honor. I just wanted to clarify with respect to the testimony that's to be served, not filed,
served, not
tomorrow. We don't have an intention to assert that the written responses themselves are confidential. With respect to at least one question, question number 2, which calls for some documents to be produced that were generated by third parties. There are some confidentiality restrictions applicable to some of those documents. To the extent that they have been or can be redacted, we'll be happy to serve them in that form. But for some, that may not be practical, at least not by tomorrow. So my question is, should we be filing a motion tomorrow to seek, I suppose, I'm not sure exactly what relief we would seek at this point, frankly, because it's partly...
To seal the record as to those and restrict. It's Rule 11.2.
But would that be timely, Your Honor, since they've had plenty of time to do
What,
that?
I mean, normally that would be brought, go ahead and file the motion to, because what you're going to be asking is to have that portion of the record sealed. You're not filing a document, you're serving testimony. This is different than, you know, there's stuff that's filed and there's stuff that's not filed.
Right.
Stuff that's filed, one rule applies to. Stuff that's not filed, a different rule applies to. So, for example, what you're be looking at is you're wanting to file a motion that would seal portions of that record because you argue some information in there should not be disclosed for whatever reasons. So, and you will file a public, you will serve a public version, and you will make the confidential version available through non-disclosure.
May I be heard on this a little
Sure.
bit further, Your Honor? And
Sure.
perhaps this would be better suited to our motion that you've requested.
Right.
Just to explain, the third parties might have a point of view about whether a non-disclosure agreement is adequate and appropriate. So it's not totally within Edison's control.
I understand, and I understand there's market participants in this proceeding, that there are interests that have been weighed by the Commission previously and will be weighed again as to whether what is sought to be placed in a confidential form to be sealed from the general public. That's going to be under a motion, and I'll rule on it when I see what it is. And the motion should include why, what's being excluded, and why, what's the basis for it. And as I said before, I would expect those to be very surgical.
But Your Honor, if that's going to be tomorrow...
Excuse me, I've got a conversation going with Mr. Weissman. So, are we reasonably clear on how you need to proceed?
Yes.
Excuse me, can you step down from the dais? Thank you.
Your Honor, I have an objection, though, and I'm a party, and this affects us.
I'm not to you, Mr. Aguirre, yet. So, Mr. Weissman, are we clear on what I'm asking you to do?
I believe so. I believe we will be filing a motion to treat under seal certain exhibits to one question in the
Okay.
testimony.
And that relates to your reports by outside consultants?
Yes, I believe that is
Okay. Will they
correct.
eventually be experts, though, that are...
I don't
know
that
yet.
that's
All
the
right.
case.
So that's fine. You need to tell me your legal authority for getting them filed, this proportion under seal. Parties will have an opportunity, like any other motion, to oppose the motion and make an argument that it should not be kept under seal, and will rule.
Your Honor, that's untimely. It's untimely because that means he's not going to serve, you ordered that they serve that testimony. That means he's not going to serve the testimony that you ordered to be served.
Now, Mr. Aguirre, we have a process. This is not new to this proceeding. Perhaps you're new to the commission, but this is not new to this to the proceed. And excuse me, I'm going to finish my comment. All right. The way this works is they get an opportunity to identify information which may be appropriate to file under seal. The commission, we may disagree. The parties may disagree, but they get an opportunity to make the argument. Where the turnaround time for that, now, it's one resolution is that parties, as they do in lots of proceedings, is enter into non-disclosure agreements. This is not an unusual practice. So there are mechanisms for parties to get to information that would otherwise be inappropriate for public disclosure based on the varying factors that we have to weigh here between open proceedings and effective participation and not disclosing certain information which can impair the business results.
But those have to be done in a timely way, Your Honor.
Okay.
But the net result of what you're doing is he will not be complying with your order to produce the testimony tomorrow because he will use the fact of a pending protective order motion not to produce the records. That should have been done previously, and I'm very familiar with substantial rights that are supposed to be protected by your rules and due process.
All right.
And that's an improper ruling on your part because you're now allowing him not to comply with your order.
You're entitled to your opinion, Mr. Aguirre.
Was that
All right.
wrong?
You're entitled to your opinion.
I know, but is it wrong?
I'm not going to
Is he gonna-
pre-rule on something. All I'm suggesting is that we follow the procedure that we normally follow, and I'm done, Mr. McGarry. I'm done.
It's
Are there?
Aguirre, not McGarry.
Aguirre. I said Aguirre.
No, I thought you said McGarry, sorry.
Are there any other questions or comments? Moving on from discovery to just in general, is everyone fairly clear about where we're going from here? We'll see a scoping memo coming out with from Commissioner Florio and I. We will be considering the comments you've made today. We'll be considering the comments you have filed in all the various forms, and we will be scoping phase 1. And there are no signs in here. There are no signs in here, please. Please. All right, this is out. You will be out. All right, we are adjourned. Thank you. Out. I'm a citizen. You're a citizen, and this is a public.
We breathe air, we use the soil, and we don't want to radiate future generations. It's not just about procedure, it's about unborn children. It's not just about money.
This is not a shelter.
It's about our children, your children, and your own children. Fukushima.